Whether you are a lawyer handling complex financial crime matters or a business person facing provisional attachment, this is a must watch. Hello and welcome to this new episode of White Collar Crime Legal Series. This is Dr. Arjun Chowdhury, advocate, and in this video, we decode a very strategic area of litigation under the Prevention of Money Laundering Act. The modes and modalities to legally challenge ED's attachment of property. Let's get straight to the point. Attachment under PMLA is the provisional seizure of property suspected to be proceeds of crime. The Enforcement Directorate issues a provisional attachment order under Section 5(1), usually soon after a predicate offence is registered and linked to the tainted assets. This power is ex parte, which means no prior notice is given to the affected party. But here is the key. Provisional attachment is not final. It is just the first step. The real battle starts after the ED files its complaint before the adjudicating authority under Section 5, subsection 5. So let's understand the immediate legal remedies. Once the attachment order is passed, you must act swiftly. The timelines are very tight. Watch for the provisional attachment order and the ED's original complaint before the adjudicating authority, which should be filed within 30 days of attachment. You have the right to file a detailed reply and interlocutory application under Section 8(1), challenging the legality, necessity, and proportionality of the attachment. You must know the key defenses, which includes the property is not proceeds of crime, no nexus between the alleged offence and the asset, the predicate offence itself is pending investigation, discharged, or weak. ED must establish reasonable belief backed by tangible material. A mechanical attachment can be struck down. Now comes the adjudicating authority battle. This is your first major forum of challenge. Under Section 8(2), the adjudicating authority gives the opposite party a full hearing. But here is a litigation strategy tip. Documentary rebuttals, forensic tracing, and third-party ownership evidence play a key role in convincing the authority that the property is untainted. If the authority confirms the attachment under Section 8(3), the property remains frozen during the trial. If it is released, you win at the very first level. Remember, this is not a mere show cause stage. It is a full-fledged quasi-judicial proceeding. File an affidavit of ownership, get chartered accountant reports, use banking trail audits, whatever it takes. But if the attachment is confirmed, the next step is to appeal under Section 26 of the PMLA before the Appellate Tribunal within a period of 45 days. Now this is your chance to highlight errors of law, lack of evidence, and procedural violations. Cite relevant case laws. For example, Mahanivesh Oils versus the Directorate of Enforcement, where the Honorable Delhi High Court ruled that mere deposit of funds without criminal intent does not justify attachment. Kaushalya Infrastructure versus ED, where third-party bona fide ownership was upheld, and other judgments which relates with the facts of your case. If both forums fail, don't hesitate to invoke Article 226 of the Constitution of India before the jurisdictional High Court. Grounds like violation of natural justice, non-application of mind by the ED, abuse of power, or colorable exercise of jurisdiction can be challenged in writs. Also keep in mind, if no charge sheet is filed in the predicate offence within a reasonable time or the accused is discharged, you can seek detachment. Even during trial, you can move an application under Section 8(6) for release if no nexus to crime is established. So to sum up, don't fear an ED attachment. Fight it legally, systematically, and with evidence. If you are facing an attachment or advising a client who is, act fast, preserve records, and challenge every procedural flaws. This is Dr. Arjun Chowdhury, advocate. See you in the next video. Jai Hind.